Good day and welcome to Letters and Politics. I'm Mitch Jeserich. The Supreme Court on Wednesday night, in a split 5-4 decision, decided not to stop the implementation of Texas's anti-abortion measure that makes it illegal to perform an abortion after a woman has been pregnant for just 6 weeks. Many, if not most women, don't even realize that they are pregnant until after 6 weeks. The Supreme Court sometime in the future will likely see a case challenging this law, but until then, Texas's Senate Bill 8 will be legal and will be in effect. What's striking about this decision is the Texas law purposefully and blatantly violates earlier Supreme Court decisions like Roe v. Wade and Planned Parenthood versus Casey that say the states cannot restrict a woman from having an abortion unless the fetus has reached what's called the viability stage, which is about 22 to 24 weeks after conception, in which it can survive outside of the womb. So in other words, the Supreme Court just gave Texas permission to continue violating the law, at the very least, until the Supreme Court hears a case concerning the law. Now, this is not hyperbole. Several states have already passed laws with the purpose of violating Roe v. Wade in the hope that a new conservative supermajority court will overrule Roe in the future. In fact, the court will hear oral arguments next month in a case from Mississippi that attempts to do just that. Today, we bring you a conversation I conducted late yesterday afternoon with Michele Goodwin about the big picture here, the future of the right to an abortion, the future of the Supreme Court, and how both of these are rooted in history. This interview occurred before the court made its decision last night, but the court had already tipped its hand the day earlier, in which it refused to stop Texas's law to go into effect on Wednesday, so the interview still holds. Michele Goodwin is the Chancellor's professor at the University of California, Irvine, and the founding director of the Center for Biotechnology and Global Health Policy. She is the author of the book, Policing the Womb, Invisible Women, and the Criminilization of Motherhood. She is also host of the podcast On Issues with Michele Goodwin. Michele Goodwin, it is my very good pleasure to welcome you to this radio program.
Thank you very much for having me.
Thank you for joining us. I want to begin with this case in Texas, and it seems interesting to me that this new Texas law outlaws abortion after 6 weeks of pregnancy, which is clearly in violation of the Roe v. Wade decision and also the subsequent Casey and versus Planned Parenthood decision that went into the issue of viability, which I think is somewhere like 22 to 24 weeks, roughly speaking, when a state could start to regulate abortion. It seems to me this law in Texas was specifically meant to violate Roe v. Wade in order to challenge it. Would that be accurate?
Your intuitions are correct, Mitch, because what we've seen over time coming out of Texas, the Texas legislature, have been a number of laws that have sought to undermine both Roe v. Wade and Planned Parenthood v. Casey. So we've seen at least two of those laws actually challenged before the United States Supreme Court within the last 5 years. That's the whole Women's Health v. Hellerstedt case where the court overturned those two Texas laws. But your intuition that this law seems to fit with an anti-abortion effort being carried out by the Texas legislature, you'd be right on point with that, because both Texas governors now and in the past, as well as state legislatures, have said that that is part of their agenda.
Now, the news is being driven today because the Supreme Court refused to stop the law to going into effect. The fact that it was such counter to what we already had in previous Supreme Court decisions, is it surprising that the Supreme Court let it go forward?
Perhaps less surprising with the current composition of the Supreme Court, and I'm sure we'll talk about that. I think we have to see this as part of its historical arc, because that gives us perhaps even more insight and more questions as to this Supreme Court, as well as the Texas legislature. So if we go back to Roe v. Wade, it's 1973, and it's a 7-2 opinion. So it's not even close. And 5 of those 7 justices are Republican appointed. The case is actually written by a Nixon appointee. Justice Blackmun was put on the court by Richard Nixon, and he's unequivocal in the opinion. If to read Roe is not to see the Supreme Court kind of equivocating about abortion being a fundamental right. The autonomy and privacy that one has in her own body. The court does not equivocate about that. In fact, Justice Blackmun talks about a history of abortion being legal in the United States historically. And then the justice talks about, then with the backing of the majority of the Supreme Court, how a failure of a state to protect this very important right could lead to innumerable harms that are faced by women. None of that has changed, but there are other things that have changed, including the composition of the court, including as well the ideology of Republicans. So again, there, 7-2 opinion, 5 of those justices being Republican. In Planned Parenthood v. Casey, it's a plurality decision, and the 2 justices that basically write the opinion are Justices Kennedy and O'Connor. Again, both Republican appointees to the court. Today, being Republican on the Supreme Court or having been appointed by a Republican judge may mean something different in the court today. And that's unfortunate because the court is supposed to be nonpartisan, not even bipartisan, nonpartisan, having no engagement in the politics of the time. But it is hard to see now either the Supreme Court or lower courts as being immune to the current breezes of American politics.
I've always found the story of Harry Blackmun writing Roe versus Wade a fascinating story. And I mean, Harry Blackmun, as you indicated, went deep into history, including into the ancient world, to talk about the history and the traditions of abortion. He spent months at the Mayo Clinic researching the science about all of this. I mean, it's really obviously the scope of the decision is vitally important, perhaps the most important aspect of it, but the way it was written is a really interesting read and probably one of the great decisions of the Supreme Court.
Well, you would be absolutely right. I mean, to be clear, when Justice Blackmun writes this opinion, just as you say, this is after months of research at the Mayo Clinic. And he was from Minnesota, very familiar with the doctors at Mayo. So this was after months of research, consulting various archives so that the opinion itself leans into medicine. It leans into history. It leans into sociology, all of those various areas. And it builds upon Griswold v. Connecticut and the court leaning towards this in other cases. So Griswold v. Connecticut, a case that legalizes access to contraception for married couples. It comes after Eisenstadt v. Baird, which is only a year or two before, which legalizes contraception for single individuals. And what the court is amassing is this doctrine on bodily autonomy and privacy to be shielded from the actions of random state legislatures. And it's also important to note that Roe also comes after Loving v. Virginia. So, across the country in these various ways, there being state legislation that would curtail an individual's right to marry the person of one's choosing based on race, or curtail an individual's right to access contraception. And also what's interesting is that in thinking about this right to privacy with regard to the body, something that the court gets from Loving, and often these are not connected, Loving and Roe v. Wade, but the court talks about reproduction because reproduction is the argument that's being used by conservative legislatures at that time to ban interracial marriages. The concern is that coming from interracial marriages will be offspring. And there is a stereotype and stigma that's being used in those conservative states to say that offspring from interracial marriages will be born with disabilities. And if not born with disabilities, that they will face social scrutiny, etc. What's interesting about Roe v. Wade and its connection to Loving v. Virginia is that the court is also talking about bodily autonomy no matter what you choose to do with your body in terms of reproduction, whether it is terminating a pregnancy or carrying a pregnancy to term and being able to do that on your own terms without the interference of the state.
The Texas bill, also known as Senate Bill 8, is not the only measure that is blatantly violating Roe versus Wade and then trying to hope to get a favorable decision in the courts. Mississippi has such a case. The Supreme Court will hear that decision this fall. I do want to talk to you about that in a moment because you've written about it in the past. But one other thing about that separates maybe the Texas law and makes it peculiar from the other ones is its enforcement mechanism. It's not the state of Texas that would enforce this law of banning an abortion after 6 weeks of pregnancy. Instead, it allows citizens to sue whoever is participating in that abortion, whether it be a clinic. I heard it could even pertain to if Uber gave you a ride to the clinic, whatever it may be. And hence, I've heard that complicates the jurisdiction of where this case would go. And there are supporters of this law saying this actually shouldn't go to the United States Supreme Court because it basically deputizes citizens to deal with this. This is something that should be handled at the state courts instead.
That's right. So it's important to understand that this law and the Texas, and the Mississippi law and the others like it are not part of a new strategy. These are part of an older strategy over time to figure out what are the best means to go about fundamentally altering and upending Roe v. Wade. And so just as you said, what this law provides for is a private right of action by an individual to be able to sue and to be able to recover against individuals who aid and abet an individual in being able to terminate a pregnancy. And so the concern is that, yes, if it's an Uber driver, if it's a receptionist at a clinic, if it is the bus driver on the city bus, whomever aids an individual on her path or their path to be able to terminate a pregnancy could ostensibly be sued by this individual. Now, what makes this unique, but also a part of history too, is that typically an individual who is harmed by a state law is able to sue the person responsible in the state's government for the enforcement of the law. So in any given state, when there is a law, there is a mechanism by which the state is able to enforce its law. And there is some agency, and that agency generally has a head. And the individual who's harmed is able to sue the head of that agency, essentially, right? That's in simple terms. But interestingly, what Texas has done, which is a very clever play here, Texas won't be alone because there are anti-abortionist and movements that have come together to figure out these strategies and deploy them around the country. And so instead here, there has been the kind of weaponization of citizenry that any given citizen can, be the person who is the enforcer, making it very difficult for the person who's harmed by the law being able to seek justice and do exactly as you said, being able to use the court to vindicate their right. But let's also pay attention to the fact that in another way, this is not new. So I don't want to conflate slavery with a woman being able to terminate a pregnancy, but yet at the same time, it's really important to understand some of the kind of historical connections here. So in the United States, when fugitive slave laws were enacted, a private right of action was given to citizens, and this was buttressed by financial incentives to go and interfere with an individual seeking his own or her own privacy, liberty, autonomy. There is a similarity here. When these laws were challenged through the Supreme Court, and famously in a case called Prigg, the Supreme Court upheld such laws, right? So sort of the action of the private citizen to aid in the upholding of legislation that is basically slavery. So if we could digress from the exact distinctions of slavery versus a person who is not enslaved, what does remain between the two, and that is relevant for this conversation and for law itself, is that this private right of action in citizens to be able to interfere with another's constitutional right or human right actually dates back centuries in the United States. And that is also quite worrisome here.
Is that to say the mechanism of enforcing this Texas anti-abortion law was very similar to enforcing the Fugitive Slave Act of the, I guess
it has powerful similarities that I wish did not exist.
Yeah.
And let's be clear, there would be some that would say, well, that's an extreme comparison, and it's not. That weapon, it is clear. I mean, we might want to call it extreme because the Texas law is extreme. Slavery was extreme. The very idea that private citizens are empowered to surveil others and to interfere in the privacy, autonomy, and liberty of others is extreme. And let's be clear, if we substituted abortion here and we said guns, or we used something else, I think others would see the extremity of it, how extreme it is.
I may be way off here, but we did a show not too long ago with historian Kara Cook Bell, who wrote about enslaved women who escaped, and she did a lot of her research on this by the private advertisements that were put in newspapers. Which I don't know. For me,
that the similarities are there. I mean, what's so sad is that there is a resistance. There's a resistance to understanding the historical foundations of our nation. There is a resistance to understanding and acknowledging history. And when it is that we do, the similarities, the proximity of the similarities are plainly there. If we would add to it that those who have been most affected and harmed by the Texas anti-abortion measures have been the poorest of Texas women, have been women of color in Texas. We haven't even begun to talk about how Texas is considered one of the deadliest places in the developed world for a person to be pregnant. That's not, those aren't my frames. Those are the frames from reporters in Texas that we can track through maternal mortality statistics that are regularly posted by the Federal Bureau of Investigation, the FBI and the CIA on websites, federal websites that compare the United States with other countries abroad in terms of how it is that we do when we're talking about maternal mortality. This places people in Texas who become pregnant in a very, very difficult position. It's a deadly proposition to be pregnant in Texas, and that is not hyperbole. That is just based on national data, unfortunately. And then now add it to with this kind of measure only undermines the entire enterprise of pregnancy in Texas.
Do you think the Supreme Court refused to put a hold on this law, why it conceivably will be making its way through the courts, because of this issue of whether or not the Supreme Court has jurisdiction over it?
You know, it's unclear exactly why.
Because they didn't say anything.
They didn't say anything, and that's also been quite disturbing, the dramatic uptick in what are called shadow docket cases. That's when the court doesn't actually issue an opinion to support why it's made some decision or that its omission is a decision itself. During the Trump administration, we saw dramatic multiplying of these shadow docket decisions that did not have any opinion attached. So we don't know exactly why it is that the court refused, at least as of now, to intervene. What we do know is that the Supreme Court looks very different than it did even 5 years ago when the Supreme Court struck down 2 Texas laws that also sought to infringe on abortion rights. The court at that time still had Justice Kennedy and also Justice Ruth Bader Ginsburg. That was a court before Justice Kavanaugh and before Amy Coney Barrett. And so what we don't know as of right now, we don't know how the court's going to rule in the Mississippi case. And we don't know if the court was waiting to give further deference to the Fifth Circuit, which intervened and did not allow the district court in Texas to further its review and issue its final opinion. We just simply don't know.
It wasn't that long ago that it seemed like the prevailing view, including within the pro-choice movement, was that the Supreme Court is unlikely to just straight overturn Roe v. Wade. It would be more likely to allow more restrictions to be put in place, but doubtful that Roe v. Wade itself would be overturned. Is that still sort of the attitude, or is there a bigger question mark to it now?
I think we have both. I think we have both the bigger question mark, because some of that was pre-Justice Ruth Bader Ginsburg's passing. Now with Justice Amy Coney Barrett on the court, she made clear from the Rose Garden that she fashions her jurisprudence along the lines of Justice Scalia. Justice Scalia, during the time in which he served on the court, was one of the most conservative justices on the court. He sort of could be in competition with Justice Clarence Thomas. But given that she was very clear in terms of how she sees her jurisprudence, and also what's clear is her personal writings and leanings on the issue, that doesn't hold any promise for the upholding of abortion rights altogether. Right? I mean, one could see that Justice Scalia was of the ilk, the kind of judicial ilk of do away with Roe v. Wade altogether. Abortion is not mentioned in the Constitution. He would have been a justice that could have seen Roe end right away. If Justice Barrett is of the same, then she could be that way. But there's a much more complicated story that's presented by Chief Justice John Roberts, and possibly by Justice Gorsuch. John Roberts, for sure, the possibility with Gorsuch is an interesting one, because Justice Roberts has had to, in recent years, be concerned about his legacy and also the perception of the Supreme Court altogether. Yeah. During the Trump administration, President Trump was critical of the Supreme Court and federal judges, saying that the cases where there was some disfavor with Trump administration regulations, that was because those judges were Obama appointed. The Chief Justice came out with a statement after some pressure, actually, by some judges. And he said there's no such thing as Trump judges, Obama judges, Bush judges. I think it's very clear from June Medical v. Rousseau, which was another abortion case from 2019 to 2020 term, where he sided with the liberals, that he's having to sort of think about the legitimacy of the court, not because he supports abortion rights per se, not at all. But in that case, we saw Louisiana bring forward a law exactly like the Texas laws that have been struck down by the court in 2016, and the Fifth Circuit carving out room for that particular abortion law, which mandated admission privileges by doctors, and the Fifth Circuit saying, yes, this is permissible. What was John Roberts to do with just a few years ago, the Supreme Court striking that down? And so he joined the liberals. The law was struck down. And so Roberts is somewhat up in the air, and possibly Gorsuch, possibly.
This is Letters in Politics, and we are in conversation with Michele Goodwin, who's a Chancellor's Professor at the University of California, Irvine, and the founding director of the Center for Biotechnology and Global Health Policy. She is the author of the book, Policing the Womb, Invisible Women, and the Criminilization of Motherhood. It is interesting to think about John Roberts, and then interesting to think about, we did see John Roberts behave like a swing vote on the Supreme Court when it was 5-4. But with the death of Ruth Bader Ginsburg and the confirmation of Brett Kavanaugh, now the new swing vote seems to be Neil Gorsuch, which he's had moments of independence, I guess. Mm-hmm.
Sure. So if we think about the Bostock case, a landmark case protecting the civil liberties and civil rights of LGBTQ persons in employment. He's the author of that opinion before the court. It's the first time that employment rights for transgender individuals are upheld. And so with that, one doesn't want to overstate Gorsuch at all. But at the same time, to the extent that Gorsuch would recognize that upholding transgender employment rights is not inconsistent with originalism. Imagine that. And that it's not inconsistent with textualism. Imagine that. I mean, Bostock is this interesting case because in that opinion, you've got Republicans both in the majority and in the dissent rooting themselves in originalism and textualism and coming out with very different views of the case. But the very fact that Gorsuch was was part of the majority there and the author of the opinion speaks to a nuance that one can't deny in that particular case. And it's possible that the nuance here, which we saw with Justice Roberts in June Medical v. Rousseau, was the leaning on precedent. So to what extent the preservation of the precedent in Planned Parenthood v. Casey is important in these abortion cases going forward? And that is the critical question, whether they will see that these are cases that are path dependent on Planned Parenthood v. Casey, and also Whole Woman's Health v. Hellerstedt, and now June Medical v. Rousseau. So those are, three cases of the last 20 some odd years that are all upholding abortion rights.
Speaking of Supreme Court justices, and not to get too off topic, but Stephen Breyer.
Let's do it.
Stephen Breyer, the oldest serving member on the court, one of the three remaining liberals on the court. Do you have a crystal ball? Is he going to retire before next year's midterm election?
One of my frequent co-authors, Dean Erwin Chemerinsky, a little shout out there to Erwin, he suggested during the Obama administration that both Justices Breyer and also Ginsburg consider retiring during the Obama administration. He predicted that if there was a retirement, or perhaps something that would not be a retirement, such as the justices leaving the court even in the last year of the Obama administration, that could lead to trouble and the inability of Barack Obama to be able to nominate and get through another justice during his term. Erwin could not have been more prescient on that count. But I mention him in relation to the question that you've asked because he received death threats and a number of excoriating emails and communications after even suggesting that. But
Erwin
certainly what we
did.
Yes, he did.
We just talked to him yesterday. We just talked to him yesterday about his book on policing.
Yes.
If I would have known that, I would have asked about that. I didn't know.
Oh, yeah. In fact, here is that new book on policing. There it is, right there. But yes, he did. He got incredible pushback, including from feminists who said, how dare you suggest that Ruth Bader Ginsburg should leave the court? But of course, we saw what happened as Barack Obama sought to use the authority of his term and to seek to fill the seat that was left open by Justice Scalia and not being able to get Merrick Garland through. And we also see exactly what happened during the Trump administration, where it's not the same playbook that was played by Republicans, such as Amy Coney Barrett, being able to get through and sail through her confirmation hearing in the wake of Justice Ruth Bader Ginsburg's passing.
Yeah, it's remarkable. I mean, you already have a 6-3 conservative majority on the court, if that were to become 7-2, there's got to be a tremendous amount of pressure on Stephen Breyer right now, because I think the longer he waits, is if this gets closer to, say he says he's going to do it next year, you still have a Democratic-controlled Senate, barely, maybe, as long as everyone stays healthy.
Well, there's something to be said about a balance. So there would be those that would say that, look, politics should never influence who gets on the court, and that it's a pendulum, and it's a pendulum that swings. But unfortunately, we are in a space in which politics sadly do enter this space. During Trump's administration, he was able to appoint more judges to the federal courts than any other president before him, save George Washington. Additionally, to that, it's worth noting that many of the judges that he appointed, there were a number of them who didn't pass ABA muster. But in addition to that, when you think about what we care about today, such as equitable representation on the court of smart individuals, there was not one black judge that was appointed to the federal circuit courts of appeal by Donald Trump. And it is also the case that these were not bipartisan picked judges. And instead, there were lists that President Trump received from very partisan leading organizations saying these are the individuals that need to be nominated. During those nomination hearings, there are certain fundamental cases of constitutional law that we say were smart decisions that the court made that serve us well in our country moving forward. Brown v. Board of Education is one such case. But there were judges who were nominated by President Trump who could not state and refused to state that they thought that Brown v. Board of Education was a well-made decision by the United States Supreme Court. And we all must recognize that what Brown v. Board of Education stood for, not just a case about equality and educating students in the United States, but it was the case that overturned Plessy v. Ferguson, which instantiated separate but equal status in the United States.
It's interesting to think about, and I forgot momentarily there, now that Trump's out of office, about what has happened to the lower courts and the number of judges that he got passed through. Do you think that plays a role in what we are now seeing with these challenges to Roe v. Wade?
Yes, and what it is that we will see, and that again is deeply disheartening, because again, if we think about Roe v. Wade 7-2 opinion, 5 of those justices were Republican appointed. But today, that means something very different. It means partisanship on the bench, and it means, sadly, in some instances, a playbook on the bench. That's not the way that it should be. That's exactly why judges, federal judges, are protected with life tenure on the Supreme Court, so that they will not become vulnerable to the whims of any particular party. They shouldn't be vulnerable to the whims of a Democratic Party, and they shouldn't be vulnerable to the whims of a Republican Party. And to the extent that these parties become captured by the whims of their voters and certain voting blocs, then that can be dangerous. So if you think about a political party that becomes vulnerable to the whims of a kind of orthodoxy, be it a religious orthodoxy or some other kind of orthodoxy, that is dangerous for democracy, and it's dangerous for a democratic branch of government. And that would be the court. We don't need our courts to be to be deeply influenced nor infiltrated by certain political blocs that have their own agendas that are separate and apart from upholding the Constitution. That's what we need justices to do. Justices who are interested, in judges that are interested in protecting the Constitution, civil rights, and civil liberties.
I remember covering back in 2005, and I remember this because it was right around this time of year, because it also happened when Hurricane Katrina hit Louisiana and New Orleans and Mississippi. But I remember covering the confirmation process for John Roberts to be Chief Justice, and he was seen as a controversial pick at the time. But now, you mentioned this earlier, but it just makes me think about it even more listening to you, is now he's sort of the one trying to push back against what we're seeing happen to the court.
And perhaps that's what's frightening to so many people, because the Chief Justice has not been an equivocator about his own conservative leanings. But when his conservative leanings then become interpreted as a liberal stance on the court, and certainly compared to other conservatives on the court, then that becomes alarming. So let me share, for example, that after June Medical v. Rousseau, the type of excoriating discourse against John Roberts, I mean, it was really quite chilling. You had from then Vice President Mike Pence to Mike Huckabee and many others in conservative movements, politics, etc., demanding that he step down from the court. Saying that he had betrayed Republican values. And even more than that, I mean, there were those that used expletives to describe the justice's opinion, because he did issue a concurrence in the case. And so that's incredibly disturbing, too. That's also something that, is just not part and parcel of what we've come to see in the last 50 years of Supreme Court jurisprudence, but that is where we are now, that the Chief Justice, basing his opinion on precedent, could receive that kind of that kind of villainy through words, from people in the Republican Party against him is really quite shocking.
I want to come back to these cases concerning abortion and direct challenges to Roe v. Wade, and we've been talking mostly about this Texas law, and understandably so, since it's now in effect, and I guess it'll be in effect. I guess the court at some point could still come in and put a hold on it, and if especially if it gets to the Supreme Court, but at least today it is the law of the land in Texas. But more immediately, the Supreme Court's not going to hear this case soon, at least not that we know of, but it is going to hear here in the fall a different case. This is the Mississippi case? Yes,
it will. So the Supreme Court decided to take up that case. And again, what's interesting there is that the Supreme Court is taking this up with this current composition of the court. It's not the composition of the court during June Medical, and it's not the composition of the court during Whole Woman's Health. That actually matters, because if the court takes up this case, as it has, which is a 15-week abortion ban with no exceptions in cases of rape or incest, that altogether, with a different composition of the court, could possibly mean that the court just simply strikes down that law.
It's too extreme.
Yeah. On the other hand, given the composition of this current court and the court having shown its vulnerability to leaning into inaccuracy when it comes to purported medical and scientific data, then it becomes far more iffy. So what do I mean by that? I mean, first of all, these laws are rooted in a couple of things. The sort of claim that what they're doing is protecting pregnant people's health, protecting women's health. And we know that's not true when the Supreme Court itself has actually cited medical evidence that a person is 14 times more likely to die by carrying a pregnancy to term than by terminating it. So we know this, banning abortion protects health. We know that does not exist. But there's a second thing that we see that's in common between the Texas law and also the Mississippi law and some of these others. And these are sort of packaged as heartbeat legislation. And I'm glad we have the time to be able to talk about this, because in a number of interviews that I've done and so forth, hosts will say, well, because you can detect the heartbeat at 6 weeks. And that is actually not true. That is the language that is being used, or even at 15 weeks. It's the language that's being used by anti-abortion movements. It's the language then that is adopted by anti-abortion legislators that are proposing this legislation, but it's actually not true. But to the extent that the Supreme Court has shown a willingness to hear out those things that are actually not rooted in science and medicine, then that also means that there is grave risk to abortion rights with a case like this coming before the Supreme Court. Now, the court can do whatever it wants to do. The court could strike down part of the law. and uphold another part of the law. The court could strike down the law altogether. And we don't exactly know what the court will do, but what this all does present, Mitch, is this question of the Supreme Court undoing, the conservative majority, undoing Planned Parenthood v. Casey and Roe v. Wade by a death of 1,000 strikes. So by upholding an individual state's law and leading into states' autonomy and so forth, which conservatives on the court have tended to do, then the court could, in fact, say, okay, when Mississippi chooses to do this, it's a law that was put into action by Mississippi legislatures. If people of Mississippi disagree with this law, they can just simply vote them out. And we'll let the law stand.
If the court were to either overturn Roe v. Wade altogether or just weaken it by 1,000 cuts, is it something Congress could remedy, could come in and create a law that would ensure women's rights to an abortion in every state?
Yes. And, and this speaks to another point in history with Ruth Bader Ginsburg. So Congress could at any time take action, and there is legislation that has been proposed by Senator Blumenthal, the Women's Health Protection Act, and it seeks to do exactly that, which is to codify Roe v. Wade. It has more co-sponsors now than ever before, and members in Congress and the Senate that have come forward to support it. And so Congress could do that. But it also complicates this story with Justice Ruth Bader Ginsburg, because famously she said that Roe came too soon. Yeah. Now, it wasn't that she didn't support Roe v. Wade. She did. It wasn't that she didn't support a woman's right to choose. She did. But the concern that Ruth Bader Ginsburg had was that there should have been more state action to protect abortion rights through states' constitutions, through state legislative action, similar to what it is that we saw with the Supreme Court ultimately supporting marriage equality. There had been a kind of movement and flow throughout the country that led up to the Supreme Court's decision in Obergefell and in Windsor that ultimately sanctified, if you will, through Supreme Court jurisprudence, marriage equality. She thought Roe came too soon because the vulnerability would be that you could see state action, just as we're seeing now.
That's the idea, that the states should be the testing ground for democracy.
Well, that's the idea. Well, that's a general idea, absolutely. But even more so, I think that she was quite cynical and alarmed by what could happen, that as feminists and others, non-feminists, supported abortion rights and thought this is a great new day. And let's remember that prior to Roe v. Wade, we have women dying in motel rooms. We have parents coming home and seeing their daughters dead in bathtubs, women bleeding out on kitchen counters and tables and things like that. The backdrop of Roe is really quite chilling and horrific. It is. And so while there would be many who then found incredible relief in the Supreme Court ruling as it did in Roe v. Wade, still, she was a bit concerned about what could happen down the line. And this is, of course, years before she would come onto the Supreme Court. As a lawyer, and as a lawyer with the ACLU, she was concerned.
I'd like to go back and ask a question I probably should have asked earlier, but it's back to the Texas law and allowing citizens to sue to enforce its ban on abortion, and whether if that would have a federal, Supreme Court jurisdiction or not, or whether that has to be determined within the own state legal system, the Texas owns top court. And I guess that is, with Roe v. Wade, it's pretty explicit. Every woman has a right to an abortion. Why wouldn't that be a federal issue? Why is the woman's right to be able to would be infringed here under the federal law? Why wouldn't that fall within the federal jurisdiction?
So that's a really good question. And this also has been part of the strategizing. So we have to appreciate that this isn't just a matter of the Texas legislature enacting this law, that this is part of years of strategizing that has been deeply funded and well oiled by some of the best legal minds being paid to think about how to best get laws through that are difficult to challenge at any court level, let alone at the Supreme Court level. So it is in using private citizens to carry this measure out that the Texas legislature hopes to limit then where individuals could seek relief against the law and first have to turn to state courts rather than federal courts. But even if they were to turn to federal courts, Texas sits within the Fifth Circuit. The Fifth Circuit has identified itself over and again as it relates to abortion rights, as it relates to the death penalty, as being one of the most conservative, if not the most conservative circuit court of appeals in the country. That was added to by appointees by President Trump. And the second part of your question gets to, well, can't we all have our rights vindicated before the Supreme Court? And generally, yes, if we have standing, then certainly we can. But this also leads to another aspect of this strategizing that's taken place. And for the most part, the Supreme Court has been good about sort of thinking about who has standing. But that is that these laws then seek to be framed not as a specific attack on the individual, such as the individual who is seeking to go into the clinic to obtain an abortion, but instead by those in the periphery. So there's something that's called TRAP laws. These are the target regulations of abortion providers. And much of the anti-abortion movement of the last 10 years, certainly between 2010 until now, it's about the last decade, have been shaped in that direction. So it's not the person who would be directly affected by Planned Parenthood v. Casey, the person who wants to terminate the pregnancy, but instead it is the provider, it is the clinic that is being put in the position where they somehow have to do a certain action or cannot do a certain action. And here it's random Uber drivers, Lyft drivers, bus drivers, secretaries, receptionists, etc.
And we may not even really get a case until the law is enforced by a citizen, and then that person who's named in the lawsuit could then challenge and say, well, this isn't constitutional. And please.
And let's be clear that on both sides this is going to be queued up, right? So there are test cases that are wanted on both sides. So you can imagine those who are part of the anti-abortion movement. And to be clear, they're not a monolith. So one can call it an anti-abortion movement, and within the context of an anti-abortion movement are silos of other movements. But they're active, right? I mean, they are. One of the things that we pay too little attention to is the fact that literally every day in the United States, there is some level of anti-abortion violence that is taking place. It's taking place through stalking, surveillance, and also through threat. It just is. This is not extremist for me to say, because if you go to any state, I mean, in Mississippi, there's one abortion clinic, and you will find that there will be protesters outside of it, either trying to block people from going in, claiming that those people are sinners, that they will not reach heaven, that they're violating religious doctrine, and that will be the mild version. And that takes place all across the country, and then it gets even more robust than that. And so when we think about, the potential challenge, we have people that are ready to lean into this law, I am sure, ready to sue. And what's also challenging about this law, and there'll be people who are ready on the other side to say, I've been harmed by this. But what's also dangerous about this law is that what will it mean for the Uber driver? Say, I don't want to be sued. I don't have to pay $10,000 to somebody. I don't want to be caught up in litigation and have to pay some lawyer. For the receptionist who might have otherwise taken the job at a clinic that performs abortion, I don't want to be sued when I check in a patient. I don't want to have to get a lawyer. So sorry, I'm not going to take that job. And all along the way, what it does is it asserts that level of pressure on individuals. And the state gets to say, we have clean hands.
Yeah.
It wasn't us. We didn't do it.
Yeah. What propelled my question about that and about standing is I was just thinking about the history of the Bill of Rights in the Constitution, the first 10 amendments to the Constitution. And for the first half of this country's existence, at least after the ratification of the Constitution, the Bill of Rights were seen as only to pertain to the federal government. They did not pertain to the state. And then in the last 100 years, that started to change with some free speech decisions, and then I think issues around
incorporated through the 14th Amendment.
And the 14th Amendment, and of course that's how we get Brown versus Board of Education, et cetera, Polly Murray, et cetera, et cetera, et cetera. But that makes me think then, what I mean, is the state of Texas trying to say that in the same vein of Roe v. Wade was a Supreme Court decision constitutionally protecting a woman's right to an abortion, is this Texas state law saying, well, we may have to abide by Roe v. Wade, but our citizens do not? And would that be akin of saying, well, you have free speech, but that doesn't pertain to people trying to, stop your speech? I don't know if that'd be a good example.
What a great question, because the First Amendment is also implicated in abortion rights. And again, not enough attention placed on this. I'm really happy that you asked the question. So the first part of your question, is this a way for the state of Texas, the legislature, to obfuscate and say that, we're not interfering with Roe v. Wade at all? That's not what this law does. If anybody takes up this law, it's the citizen that does it. I think that it would be clear that the emperor has no clothes with that kind of argument, because it's the state that is enacting a law that does exactly that, understanding what the ramifications of that would be. To craft such a unique law means a certain level of deliberation, both in the crafting of it and also in the implementation of it, right? So I think it would be clear that such a claim that we didn't know what was really underneath the very law that we enacted would be spurious. But at the same time, where the First Amendment has become implicated in abortion rights, actually does date back to Planned Parenthood v. Casey. So in Planned Parenthood v. Casey, what the Supreme Court does, and I'm sure that Justice O'Connor, didn't predict what would happen, is that when the court said that it could be okay that in the furtherance of informed consent, that a state could impose certain regulations that would help a person to understand what an abortion is and to be duly informed, that would be legal. Well, that in of itself was a bit problematic, and, problematic for a number of reasons, but let's just say problematic because of the ways in which it's quite patronizing to women, that everybody else could get any kind of procedure. A man could get a vasectomy or anything else, and he doesn't have to wait. He doesn't have to have a special script said to him if he decided that he no longer wanted to inhibit his ability to reproduce. But a woman has to be explained things in a particular way because she just can't understand. That aside, where this is now moved to is that in Texas and some other states, you have doctors being forced to read scripts that are completely antithetical to science and to science. It's stunning, right? So that doctors are forced to say things like, having an abortion can lead to breast cancer. We know scientifically that is not true. That an abortion can lead to mental health conditions and problems throughout one's lifetime. We know that is not true, and certainly no more likely than postpartum depression can result from carrying a pregnancy to term and having childbirth. And so the First Amendment is actually implicated in that doctors being compelled and forced to say something that they do not believe in, that they know is not rooted in medicine and not rooted in science.
It's strange to have citizens enforce these things.
It is absolutely strange to have citizens enforce these things, but let us also remember that in that way it's not unique. And this is deeply concerning, not just in terms of mob justice or vigilante justice,
I was thinking of those old cowboy movies of, rounding up the posse.
Well, it is, and again, there would be those today. There was an editor who told me that something like that is an extreme point of view, but it's not. I mean, we've just become immune to the violence that surrounds us. I mean, again, violence already attends every day in the United States around abortion clinics. The level of protection that clinics have to engage in, hiring security guards, having surveillance cameras, having people volunteer to walk people into the clinics, dealing with being spat upon, with their tires being slashed. And that's not even talking about the threats to bomb the clinics, the shooting up of clinics, and all of that. So that when you mention the kind of cowboys rounding people up, if we think about that level of violence already exists, without a law that says now it's legitimate for you to carry out this civil action, how might people interpret that? So there might be some that say, well, no, what this will do is diffuse what happens at clinics, because now, rather than being at clinics, people will just go to the courts. But I would compare that to the following. It's like saying, well, Supreme Court, uphold Plessy v. Ferguson, and it will mean that white people who have a view of white supremacy and believe that black people are second-class citizens will be satisfied. They won't engage in violence. They won't engage in stigmatization. They won't engage in threats. But we know that wasn't true. The whole enterprise of Jim Crow that came after Plessy v. Ferguson, I mean, it is exactly after the state of Louisiana imposes separate but equal laws that are upheld at the state level and then are sanctioned by the Supreme Court. What do we see? We don't see people acting, with, great civility, right? Saying, well, now I can just be proud that the Supreme Court has recognized white supremacy. That's not what people do. We see a spate of lynchings. We see church bombings. We see homes being bombed. This is a legacy that we may not want to acknowledge. It's a legacy that we may feel shame about. It is a legacy that we may wish did not exist. But the facts do. The facts exist that it's after Plessy v. Ferguson that we see lynchings across the United States. The truth of it is, it's after Plessy v. Ferguson that we see in Oklahoma that tragic mob violence against Black communities. It's after Plessy v. Ferguson that we have that very sad march across the Pettus Bridge and people being met by batons and bullets and so much more. It's after Plessy v. Ferguson that we see little girls bombed in the basement of a church in Birmingham, Alabama. So this very idea that somehow this means peace, that this means that part of an anti-abortion movement that has historically shown itself to be violent, mildly and extremely violent, that now that all goes away because people will be happy that now they have a Texas law and will just utilize the courts. Not so. I think that we have to be prepared that at the very least, this law further weaponizes the thinking that individuals have the right of enforcement beyond just what is in law, but extra legal enforcement as well.
Michele Goodwin has been our guest. Michele Goodwin is the Chancellor's professor at the University of California, Irvine, and founding director of the Center for Biotechnology and Global Health Policy. She is the author of the book, Policing the Womb, Invisible Women, and the Criminilization of Motherhood. Michele Goodwin, I am extremely thankful to you. You've given us an awful amount of time on very short notice, so thank you.
Thank you very much for having me on your show.